America's legal system, to a large measure, is based on Latin terms and legalese. The goal is to complicate the system so much that no one can understand it except lawyers. That's the reason that laws are called codes. It's a secret language. The first words in the preamble of the U.S. Constitution states, "We the people." That means a government of the people, by the people, and for the people. Not a government of lawyers, by lawyers, and for lawyers. In a true democracy, laws should be simple enough that any person of average intelligence can understand them. Due to advances in technology, such as the internet and legal search engines like Westlaw and LexisNexis, the legal profession is becoming obsolete. Instead of paying an attorney $500 an hour, everyday citizens now have the ability to research the law for themselves. The Sixth Amendment guarantees that in all criminal prosecutions, the accused will have the assistance of counsel for his defense. Included in the right to counsel is the right to counsel of choice. In U.S. v. Gonzalez-Lopez, the U.S. Supreme Court held that the Sixth Amendment guarantees the accused be defended by the counsel he believes to be best. The word counsel, as it applies to the Sixth Amendment, does not mean someone who has passed the bar and is licensed by the Bar Association. At the time that the Constitution was written, there were no bar exams or licensing requirements. Anyone could practice law so long as they were minimally competent. The licensing requirement did not come into play until much later when the American Bar Association began to influence the judiciary. The Sixth Amendment uses the word counsel instead of attorney. The drafters of the Constitution used this word deliberately. The common law of England made it an inalienable right to have a friend act as counsel. It is impossible for attorneys to serve as friendly advocates for their clients. By definition, the interests of attorneys are hostile to the interests of their clients. All licensed attorneys are officers of the court. Their primary loyalty is to the court and not to their clients. The public has an inalienable right under common law to be represented by friends rather than licensed attorneys. This right is not subject to revision by the American Bar Association. The fact that attorneys have been able to maintain a self-serving monopoly on the practice of law does not make it right, nor does it make it constitutional. It is an unconstitutional abuse of power for the judiciary to force the defendants to be represented by officers of the court. The U.S. Supreme Court held in NAACP versus Button that the power of the state to control the practice of law cannot be exercised so as to abrogate federally protected rights. State courts have a policy interest in protecting the efficient use of judicial resources. It would be a burden on states to allow anyone to practice law who didn't understand the basis of the legal system. Accordingly, courts are permitted to set minimum standards of competency to practice law. However, bar exams and state licensing requirements go too far. The public has consistently viewed lawyers as the gatekeepers for access to the law and the courts. However, with legal fees being so unreasonable, 65% of all domestic cases are handled without any legal assistance. The result is that only the wealthy are able to afford fair trials. Prosecutors, as well as defense attorneys, are pressured by judges into disclosing cases as quickly as possible in order to clear the docket. This often means that the wealthy get trials while poor clients get intimidated into accepting plea agreements. Most attorneys have a heavy caseload and are unable to dedicate sufficient time and attention to each of their clients. In order to prioritize, the clients who pay the most get the best service. States do not have the power to compel inadequate representation. When citizens don't have the right to choose who represents them in a court of law, they have no rights at all. Criminal defendants prosecuted by officers of the court have no choice but to be defended by another officer of the court. Does that sound like justice to you? J.P. Morgan once said, "I do not want a lawyer to tell me what I cannot do. I hire an attorney to tell me how to do what I want to do." No attorney is ever going to tell the public that they have the right to be represented by unlicensed attorneys. The problem is that there is more money in being corrupt than there is money in fighting those who are corrupt. This may seem like a rather complicated issue, but it all comes down to three words: freedom of choice. The licensing comes from the individual client and not the government. The state has no power to license citizens to practice law any more than it has the power to license citizens to vote. The practice of law is a common right. Laypersons are presumed to be competent unless they are wards of the state, infants, or found to be of unsound minds. Since laypersons already have the right to represent themselves in court, it only makes sense that they should be allowed to transfer that right to someone else. Citizens Against the Bar is an organization dedicated to protecting citizens' right to legal counsel. We have 4 specific demands. First, protect citizens' right to counsel of choice by eliminating the Bar Association's monopoly on the practice of law. Second, require that all laws be written in plain English. Third, eliminate the Bar Association's influence over the judiciary. Fourth, equal access to justice, including reasonable attorney's fees. It's time to put an end to the corporate monopoly over our legal system. Enough is enough. What do we want?
Justice!
When do we want it?
Now!
Citizens Against the Bar!
Equal access equals justice!
Citizens Against the Bar!
Equal access equals justice!
End the monopoly! End the monopoly! End the monopoly! End the monopoly! End the monopoly!